Thank you for attending Reimagining an Anti-Racist Approach to Drug Sentencing, part of the Understanding Drug Symposium. Before we begin, we have just a few notes for those of you who may be just joining us today. Note that Q&A and auto-generated transcription have been enabled for the event. Additionally, this event is being recorded. The recording will be made available as soon as possible after the event. Thank you again for joining us. Jelani?
Hello, everyone. Thank you for being here with us. Welcome to our second panel of the day, Reimagining an Anti-Racist Approach to Drug Sentencing. This panel is part of the Understanding Drug Sentencing and its Impact on Mass Punishment Symposium, and I appreciate that I had the opportunity to help plan this event along with Professor Doug Berman and the Ohio State Drug Enforcement and Policy Center. So thank you to them for inviting me, and also the Arizona State Academy for Justice and Professor and Deputy Director of the Academy, Valina Beatty, as well as Professor Mark Osler from the University of St. Thomas Law School. It has really been a fantastic symposium, as I'm sure you also feel if you've been joining in through the whole day, and I'm so excited about what we are about to discuss today. So I've been a sentencing scholar for the past 14 years or so, and as a Black woman, I have unsurprisingly been invited to talk about race and sentencing many times. Starting out as a new scholar, those invitations were always exciting, and so I happily put together information on the disparities in sentencing, the racial disparities. And after a while, though, I have to admit that got quite tiring. It's of course important to educate each other, the public, other scholars about these disparities. So it's important to know that 60% of incarcerated individuals are people of color. It's important to know that Black men are 6 times more likely to be incarcerated, or I'm sorry, 6 times more likely to be incarcerated than whites, that Black people are almost 4 times more likely than whites to be arrested for selling drugs, 3 times more likely than whites to be arrested for possessing drugs, and that Blacks are a whopping 85% more likely than white offenders to be incarcerated for misdemeanor drug offenses and severe sentencing and serve sentences for drug offenses that are almost 60% longer than those sentences served by whites. So all of this information is important, and it's important for us to know and to appreciate, but I really did get tired of reciting these numbers before audiences and then having the audience leave with little thought or discussion about what we should be doing to actually get ourselves out of this, and little acknowledgement of the racist undergirdings of these policies. And so that frustration is really what has driven changes in my own work, my current research and publications on thinking about anti-racist approaches to sentencing and punishment and policing. And it is the focus of today's panel. So as the panel description says, it's well known that drug law and policy in the United States has profoundly inequitable consequences for communities of color. So this panel today will explore the racial disparities in drug arrests, prosecutions, and sentencing outcomes. However, rather than simply presenting the data that has become familiar to many, the panelists today, who I'm very excited about, will take on their reimagined approach to drug sentencing, one that fulfills the anti-racist goals of racial equity. So I'm pleased to announce this great lineup of speakers, and I'll go ahead and introduce everyone first, and then we'll move to their presentations. First, you'll hear from Jessica Eaglin, Associate Professor of Law at Indiana University School of Law. She joined the Maurer School of Law in 2015 after several years of experience in private practice and as a judicial clerk. She serves as counsel in the Justice Program at the Brennan Center for Justice and at New York University School of Law, and clerked for the Honorable Damon J. Keith of the Sixth Circuit Court of Appeals, who we know well here at Detroit Mercy Law. She was also a litigation associate at Simpson, Thacher, and Bartlett LLP in New York City. She's an expert in criminal law, evidence, and federal sentencing law. And in addition to her JD degree from Duke University School of Law, she holds an MA in literature from Duke University and a BA in English from Spelman College. She served as a Law and Public Affairs Fellow at Princeton University during 2017 to 2018. Following Jessica's remarks, you'll hear from Addie Rolnick, Professor of Law at University of Nevada, Las Vegas, William S. Boyd School of Law. She's the San Manuel Professor of Law. Professor Rolnick specializes in Indigenous rights, juvenile and criminal law, and racial justice. She's the faculty director of the Indian Nations Gaming and Governance Program and the associate director of the program on race, gender, and policing. She's also a member of the National Academy of Sciences Ad Hoc Committee on Reducing Racial Disparities in the Criminal Justice System. And prior to joining UNLV in 2011, she was the inaugural Critical Race Studies Law Fellow at UCLA School of Law. Before that, she represented tribal governments as a lawyer and lobbyist in Washington, D.C. She earned her JD in American Indian Studies from UCLA and her BA from Oberlin College. And our third panelist will be Sean Hill, Assistant Professor of Law at The Ohio State University Moritz School of Law. Professor Hill's research and teaching lie at the intersection of critical race theory and criminal justice policy, and his forthcoming publication in the UCLA Law Review specifically examines bail reform and pretrial risk assessment instruments through a critical race lens. So prior to joining Moritz, Professor Hill was a law research fellow and adjunct professor at Georgetown University Law Center. He serves as a member of the Law for Black Lives Sentencing Committee, Steering Committee from July 2015 to March 2017, and as co-chair of the National Conference of Black Lawyers, New York chapter from January 2016 to March 2018. He earned his undergraduate degree from Duke University and his JD from Harvard Law School. So just from those introductions, you can understand why I'm very excited for you all to hear from these three panelists and to get their vision for approaching drug sentencing through an anti-racist lens. So I'll turn first to Professor Jessica Eaglin.
Hi, thank you so much for having me. It is an honor to be on this panel. I have admired Professor Jefferson-Exum's work since I started writing. So she might have been tired of hearing herself recite all these statistics, but I never got exhausted by it. And thank you also to the entire team of organizers that have pulled together this great event. It's just been such a pleasure to listen in and be a part of this conversation. So in my remarks today, I want to reflect a little bit on the nature of drug crimes in social and historical context, and ask this question, not really how did we get to this place, but why is there enthusiasm to think about drug sentencing in particular and as a popular space for criminal justice reform? And my central claim is that drug crimes are popular for a variety of reasons, but only some of these reasons actually provide or intersect with an anti-racist approach to sentencing. And primarily here, what I'm trying to get at is that the driver of racial inequality in the United States is structural marginalization, and some of the rationales for drug reform intersect with, but can also undermine efforts to think about and address racialized structural marginalization in the United States. And I'll conclude with a couple of examples, thinking about ways that some reforms don't facilitate that kind of thinking, and then some reforms that do. So I will start by thinking a little bit about why drug reform is popular in this current moment. And this part of the talk is really things that we all probably have heard already throughout the excellent panels that have been ongoing in the last day and a half. One of the primary reasons that drug sentencing is controversial in sort of popular imagination is the growing awareness of racial disparities in individual treatment, and the powerful statistics that suggest that while African Americans and Latinos may use drugs at similar rates as white individuals, African Americans in particular, but people of color more broadly, are far more likely to be arrested, to be incarcerated and to experience longer terms of punishment for the exact same sort of for similar offense. So, so racial disparities, and of course, I believe, I mean, so many people mentioned it, but in the presentation yesterday, former Attorney General Holder referenced this in great detail, including a reference to Michelle Alexander's book, which we all know really brought drug sentencing to the fore, and racial inequality in drug enforcement to the fore. But that's not really the only reason why we're interested in drug sentencing reform, right? One of the other reasons, and something we've heard a lot about throughout the presentations, is the way that drug sentencing or drug enforcement has transformed criminal administration and transformed it in ways that have sort of undermined certain checks and balances. No place is this more sort of prevalent than thinking about mandatory minimums, which have been, a driver of punitiveness in criminal sentencing and have hamstrung particularly judges' ability to sort of think about sentencing less punitively going forward. And then finally, a big driver is that there's been this sort of cultural shift, a recognition that the nature of drugs themselves are now conceived as a nonviolent, victimless crime that is deserving of less punitive interventions. And we can think about that through a sort of punishment theory perspective. Some might say these individuals are less or are more deserving of less punitive interventions because they are the crime itself is not as serious, but also by these consequentialist sort of rationales of saying there are other ways that we can sort of reduce harm going forward on the basis of sort of the nature of drug crimes. There's better ways, there's more effective ways for us to intervene, which is captured also in this broader sort of pendulum swing around drug crimes or drug offenses more broadly, and particularly as we start to think about sort of the war on drugs as a failed war, one that we are still very much in, but one that there's a lot of recognition that it hasn't been effective in even its own stated goals. All right, so this is sort of, these are the foundations that bring so many people to the sort of, to the well of drug sentencing reform. And all of these reforms have, or all of these sort of rationales have led to a variety of interventions specifically aimed at sentencing of drug offenders in response to the economic and social pressures of mass incarceration. Many of the reforms have been referenced throughout the symposium already, things like drug courts, things like reducing or eliminating mandatory minimums, expanding diversion programs, and even partial or total decriminalization of certain drugs in the criminal system. All right, but the important part of this conversation, when we think about this from the context of race, is that these interventions, while they are important and they raise important, or these rationales, while they're important and raise important rationales on their own, do not in and of themselves guarantee that drug reforms are going to be, drug sentencing reforms are a foundation for an anti-racist approach, because the central driver of the nature of racial inequality in the United States is structural, meaning it is driven by systemic allocation of resources along racial lines, rather than, for example, individual prejudices. Not to say that there aren't individual prejudices, but we need to start to think about drug crimes in a structural framework. And it's not necessarily the case that drug sentencing or drug crimes lend themselves to thinking about racial inequality through a structural lens. Part of this is because what is underlying drugs, or sort of another thread that underlies the nature of drug crimes, is that they're largely conceptualized as individual failings. So individual addiction, individual harm, even if it is nonviolent, particularly when we talk about sort of the quote unquote low-level drug offenses, things like possession, are often conceptualized in a context that resonates because we think that it is an individual problem. This can contradict and lie in tension with a conceptualization of racial inequality as a structural problem. Even though there are lots of studies that demonstrate that addiction and more broadly involvement with the drug trade intersects with and exacerbates existing structural inequality in the United States. So lack of access to jobs, lack of access to education, lack of access to healthcare, these types of structural disadvantages can lead to individuals using drugs, trading drugs, or selling and distributing drugs, and in some cases, drug addiction itself. So the peril then, when we start to think about racial inequality through this lens, is that drug reforms are going to actually entrench and deepen already existing structural inequality along racial lines. And there are lots of examples where drug reforms are doing just that. So one example are drug courts, very popular diversion programs that were designed for efficient management of large numbers of drug cases in criminal system, and can lead to diversion either pre-trial or more frequently post-conviction, diversion from long terms of incarceration to alternative sanctions that can include supervision in the community and treatment programs. However, and these programs tend to be conceptualized as evidence-based and proven to work, quote unquote. However, there's also evidence that suggests, or studies that suggest that investment in these programs have operated to reduce enthusiasm for non-carceral treatment programs, non-carceral health interventions, that would capture more than just individuals who are drug addicted, but also individuals that are experiencing structural marginalization more broadly. The treatment programs often cost money that individuals who are less likely to have additional resources, again, going back to racialized structural marginalization, are more likely to be captured in the criminal justice system for longer, or to quote unquote fail the programs for technical violations that may include failure to adhere to conditions that prevent them from getting a job, or failure of conditions that require them to get a job, all things that are connected again to structural inequality. So in this context, drug courts themselves are not necessarily a solution, a long-term solution to racial disparities. And we heard in the previous panel that in fact, a lot of the reforms that have been implemented, drug courts being one of the most popular, to reduce prison populations have actually led to, or have not addressed at all, racial disparities that exist along racial lines in the context of drug sentencing and beyond. The other example that I want to talk about very briefly is partial decriminalization of drugs in particular. So there has been a real enthusiasm to reclassify low-level drug offenses, again, particularly things like possession of small amounts of marijuana, but other low-level offenses related to drugs as well, and reclassifying them from what would have been a felony into a misdemeanor or a non-jailable offense. So whatever it is, whatever it's been classified as, it can no longer result in a term of incarceration. So this is not the same as legalization, right? This is not drug legalization. These partial decriminalization reforms, things like Proposition 47 in California, which reclassified low-level drug and theft felonies to misdemeanors in 2014, have the potential to reduce incarceration because it does prevent people from literally directly being charged and convicted of a crime based on this possession of drugs or of that nature. But it also has the potential to exacerbate structural marginalization because it leads to an epidemic of misdemeanors. There's been a lot of research in recent years talking about the expansion of misdemeanors that produce their own foundation for some of the very perils that we see in the context of drug incarceration in prisons, things like selective enforcement, the exacerbation of the lack of resources, both in and out of criminal legal apparatus, the expansion of fees and fines, the expansion of criminal records, and more, again, along racialized lines. So on the basis then of people who cannot pay the fees and fines that may be implemented as an alternative to incarceration, the people who are still being policed in communities that are, majority Black and Brown, majority impoverished, or primarily impoverished. And so again, these communities that are already lacking in resources are most likely not to be able to benefit from the reforms that focus on partial decriminalization. So the point is to say there's no foundation. Just because we change the way we approach drugs does not mean in and of itself that we are adopting an anti-racist approach to drug sentencing. What does an anti-racist approach to drug sentencing look like? Simply stated, it starts with structural marginalization, not drugs, right? So part of that means treating drugs not as an individual failing, but instead as a societal failure. Thinking about how repeat interactions with the criminal justice system that may be facilitated through drugs are actually a product of and reproducing racialized structural marginalization. Thinking about sentencing defendants not only on the basis of not just drug weight, but also what is going to happen to this person after they have entered the criminal justice system. The fact that arrests and convictions have significant impacts on an individual's life chances because of the way we treat criminal records in society more broadly. They're less likely to be able to get a job, more likely to have a hard time with finding housing, et cetera, so on and so forth. Rethinking fees and fines, the people who are most likely to get these convictions are also most likely to be the people who are unable to pay them. And starting to talk about that, right? And we heard that in some of the earlier panels where judges have been restricted in their discretion, but they haven't just been restricted in their discretion, they have been limited in their ability to think and talk about structural inequality in ways that can raise awareness, not just about the problems of drug crimes, but the problem of racial inequality in society more broadly. So I'll leave that there, and I'm looking forward to the conversation and my co-panelists' thoughts as well.
Great, thank you so much for that, Professor Eaglin. We will now move to Professor Rolnick. You're on mute.
What I was saying there was you can hear me, correct? So it was good that I said that. Thank you for inviting me to be part of this panel. I am a big fan of everyone who I'm on the panel with. And I want to kind of take off of what Professor Eaglin spoke about to explore, I'm going to explore a little bit more about diversion and decriminalization. So I'm going to back up a little bit and just start with the premise that we have a mass incarceration problem in this country and that it is a race problem. So just to decouple the premise a bit, first is the idea that criminal systems in the US are over-reliant on incarceration and specifically on extremely punitive forms of incarceration in which people are warehoused and receive few services. And then the second piece is that minoritized communities bear the burden of this criminalization and incarceration disproportionately. So 15 or 20 years ago, it would have been much more radical to argue that mass incarceration was a problem and that I would have had to spend a lot more time convincing you that its effects have been racially unequal. But we're in a moment of fairly widespread acceptance of these two ideas. So I'd like to just take it as a given that this audience is interested in reducing reliance on incarceration and perhaps in reducing the reach of the criminal system more broadly, and that this audience is also interested in reducing or eliminating the racial inequalities that go along with it. So the harder question, I think, is how to do that. Because there's such widespread interest in these ideas now, you get a lot of discussion about promising alternatives, and I think way too little discussion about what those actually might look like. So that's where I want to focus. So I'm going to focus on two ways to do this, and I want to talk about what I mean. So I'm going to talk about diversion and decriminalization. My remarks are going to focus on drugs and on Native people. Some of my research has been on Native people in the criminal system, but nothing that I'm saying I think is limited to the problem of drug crime or to Native people specifically. So backing up, I think there are two key choices that have driven mass incarceration. One is the choice to criminalize, and the second is the choice to punish. It's important, I think, to understand that these are both choices. When confronted with a problem or behavior that causes a harm or a disruption in society, governments have a range of choices about how to respond. When we stop seeing the places where the choices are made, that's when our uniquely massive system of imprisonment starts to feel unavoidable. So the most obvious choice to focus on, and I think what a lot of this conference is thinking about, is the choice to punish, sort of how and how harshly to punish. So more specifically, we have kind of been embedded in a system that has made the choice to punish drug offenders for very long prison terms. Legislatures have responded to drug crimes by imposing long terms. Sometimes it's through statutory sentences. Sometimes it's through enhancement rules that can increase sentence length if any offense is drug related. And then inside prisons, those incarceration terms often are not attached to any kind of rehabilitation or services. So if we focus on this choice, the choice to punish, there are a range of interventions that we might consider, including reducing sentencing length, increasing the flexibility of sentencing, introducing more treatment and rehabilitation into prisons, or diverting offenders into alternative programs that we hope will never lead them to prison. So some of the other panels have talked about the other options. Diversion is the one that I want to focus on here. So we have this massive criminal system infrastructure that is vast and complicated. And very often, I think the most expedient and politically feasible way to introduce alternative approaches is by sort of appending them onto the system that currently exists. So diversion is the word that I use for that. I'm using it broadly. So depending on where you work, you might use the term diversion more specifically. But what I am talking about is an exit point from the system. So we might think about before charges are filed, you could divert someone out of the system. Before a plea is entered, you could divert them out of the system. After their plea is entered, you could divert them out of the system. Sometimes we talk about something called deferred adjudication. So you can sort of wait on adjudicating the offense while someone completes a program, or it can be part of the sentence, right? It can be a post-adjudication diversion. So I'm just using the word diversion as an umbrella term for all of that. And because this is sort of a middle ground between abolishing or shrinking the entire system and using what we currently have, I think there's a great deal of interest in how we can use this sort of diversion model to explore alternative approaches. So I want to talk about a little bit about drug courts in general, but I'm going to talk more specifically about how tribal communities have used the drug court model. So I'm going to talk about something called healing to wellness courts, which are the tribal and Native version of drug courts that have been used over the last 10 to 15 years. And then mostly what I want to do is sort of suggest that there are some pitfalls and notes of caution that we should be concerned about when looking at these alternative models. So I think that it's easy to talk about doing something different in terms of sentencing. What other kind of program can we divert someone into without spending as much attention on what that program looks like? So on drug courts generally, there is a whole panel after this on drug courts, so I don't want to spend a lot of my time thinking about the drug court model generally. But it is a model that many people have raised concerns about. So the idea is that you have a mental health related or a drug related court that is a specialty court. You take someone, depending on what system you're in, it might happen early, it might happen later, and you put them into some kind of program that is supposedly a treatment program. And it is often done through an alternative court. And then if they don't comply with that or screw that up in somehow, they'll be bounced back into the regular court. So it's not dispensing with the entire system that we have as a whole. It's just pushing someone out, letting them complete something. So in theory, this is a great model, which means we take people who end up in the criminal system, we move them out of the criminal system and allow them to do something that is treatment-based and ideally evidence-based and focused on what it is that the medical community has decided works for drugs or alcohol. And then they have a chance to successfully complete that, and then they don't come back into the system. Now, so many people have identified several problems with this. One, lots of people come back to the system, right? The punitive threat is still there. Many people fail at their diversion programs or their drug court programs, and then they end up back in the system and often will end up in prison for a violation, for example, of their agreement. We're not sure always what's going on in those courts. So what kinds of models are being used? What sorts of treatments? My colleague Sarah Gordon at UNLV has written about how drug courts often employ non-evidence-based practices such as Alcoholics Anonymous and don't necessarily provide people with any access to the most current medical models for treating addiction. And maybe they're overseen by judges who don't have specialized medical or mental health training at all. So in the way in which people have talked about the history of the juvenile system, maybe these alternative courts and these alternative models are places in which we're doing a lot of experimentation that may or may not be actually working. And there's not really a lot of oversight over what's happening there and whether the intervention is effective. So there are a lot of questions about that model. But I think it's still useful to think about this diversion model as a way in which, as sort of an empty vessel, right? So the diversion model, if you call it a drug court, that's fine. If it's another kind of diversion, that's fine. It's a bucket in which a kind of approach that we might not have thought of can be put in there. And so what I want to just say a little bit about is tribal healing to wellness courts. I'm going to try to share, I have a couple slides. I'm going to try to share these with you. All right. So this is just, this is taken from a publication called Overview of Tribal Healing to Wellness Courts that is published by the Tribal Law and Policy Institute. And this is just the 10 key components, just to give you a visual for thinking about these courts. They're not actually that complicated, but essentially tribes with support from the federal government in terms of grant funding really took this drug court model and indigenized it, right? Which is to say that they use this bucket as a way to bring in community-based, community-specific, and often traditional models for addressing addiction and offending and even violence that went along with it, and sort of use the alternative model to create these healing to wellness courts. So there's a number of judges and academics across Indian country who have been working on this. There's sort of a model that many tribes use, and these are the 10 key components. And if we go through them, they're not actually they're not that groundbreaking and difficult to understand. So it is individual and community focus of healing. So not just individualized, but it is focused on bringing the community together. The referral points and legal process piece, that's about thinking about how it is that you divert someone out of the normal criminal system and into a wellness court instead. Where does that happen and how does it relate to the other part of it? Screening and eligibility, right? So there should be a robust screening system to think about whether addiction, drug or alcohol problems are the root of what's going on and whether the person is eligible for this alternative program. Key component 4, I've got a little bit more on. So treatment and rehabilitation. Tribal Healing to Wellness Court provides access to holistic, structured, and phased alcohol and drug abuse treatment and rehabilitation services that incorporate culture and tradition. So this is the place where tribal communities have really taken off with this model, which is to say that they have often reinvigorated or just used existing traditional models for thinking about how to deal with addiction and treatment. Sometimes you're using Western medical models here, but often something else. And this is a place in which they've been able to bring these approaches into the sort of standard criminal system by using a diversion model. Then intensive supervision, incentives and sanctions, right? So quick responses, both in terms of incentives and in terms of sanctions to behaviors, judicial interaction, monitoring and evaluation of the process, continuing interdisciplinary and community education, right? So the whole community is involved in this, and then team interaction. So a lot of these will be familiar to you if you are, I'm gonna stop share for a minute. If you're thinking about drug courts at all, much of it is not that different, but the important piece here is the idea that this is an empty bucket that tribal communities have been able to use to create really, I think, interesting and effective models for addressing alcohol and drug abuse outside of the criminal system. On the other hand, if you look at these key components, it is trying to get back to my notes. Sorry, everyone. If you look at these key components, it is clear that it is attached to a standard criminal system, which is to say that if you don't do well in your healing to wellness court, you'll end up back in the regular court. I do a fair amount of work with tribal communities, thinking about how the healing to wellness courts will intersect with the normal courts, and thinking about what the consequences are for violation. So there's a lot of room to think about sort of non-punitive consequences and interventions, but most of these codes will also say, if you screw up, you could eventually be put back in jail for a short term, or you could be bounced back into the criminal system. So it's not necessarily total avoidance of the criminal context. So I want to pivot then here into thinking about another choice, which is the choice before the choice to punish, an earlier choice about what we label a crime and whether we choose to address a given behavior or social problem through the criminal system. So it is much more expedient to talk about diversion because we can just do that in the context of our current system. But for the social problem of drugs, including use, addiction, possession, sale, and attendant violence, the choice to respond through the criminal system at all has had significant consequences. And so I want to give you, again, one illustration. Sorry, I'm bouncing between my screen shares. One illustration for Native communities. So again, none of this applies just to Native people, but it gives you an illustration about the effect, the choice of criminalization. So Native Americans are 1 to 7%, or just over 2%, depending on how you count them, of the national population, 1.7 to 2. And in 2019, they were 2.4% of all arrestees. So depending on how you do that count, they maybe are really overrepresented at arrest or just a little bit, but we might think further about what offenses are driving that. And so this is just a list from the UCR of the offenses for which Native people are overrepresented, sort of more than 3%. So they're more than 3% of the arrestees. And it's offenses against the family and children. These are domestic related offenses: liquor laws, drunkenness, disorderly conduct, vagrancy, and suspicion. This is true in the juvenile system as well. The numbers are a bit different. And so here, what's important is what is driving the introduction of Native people into the system is really largely drug and alcohol related low-level offenses. So the choice to address these through the criminal system is what's bringing these people in the first place. And then what happens is you've got significant over-reliance on incarceration, significant disparities that Native people see. Many Indigenous people, this is from a report about Montana specifically, are not going to prison for a new crime, but rather for violation of their probation or parole conditions, which can include failure to enroll in or finish substance abuse treatment, failure to check in with supervision officers, or drug and alcohol use. So what we see is the introduction early in the decision to address drug crimes and drug offenses through the criminal system is bringing people in, which is then compounding through the system to result in over-incarceration. So it is, and this is sort of where Jessica was going, I think, instructive to think about whether or not we should rethink the choice to criminalize, not just the choice to punish. And so here, I don't have time until the questions to think more about this. I just want to throw out some ideas. But how else? Decriminalization is the way that we might shrink the system. It challenges the reflexive idea that we should use the bludgeon of the criminal system as the best way to address any problem. So what would it mean to think about decriminalization, to think about it differently? We've talked a little bit about it. We have some models, but I want to push a little bit more. So one possibility is we think of drugs as a public health problem. Could we respond only with treatment, decouple treatment from the threat of punishment entirely? So could we accept the medical reality that treatment will involve relapse, not put people in jail, not attach that to criminal sanctions at all, and pour money into research on best models for addressing addiction? The biggest hurdle to that is that we lack the infrastructure anywhere else at this time. We have a funding problem. This is the argument for defunding when it comes to policing, but it's true elsewhere. From my work, I can just tell you there are about 85 incarceration facilities across Indian country, including about 14 specifically designed for children. There are 8 to 10 mental health and drug treatment facilities that are comparable. So most communities have somewhere to incarcerate, but a great many have no access to really significant treatment beyond the most rudimentary interventions. So this is an important way to approach decriminalization, but it's going to require some work in laying the groundwork in other systems. Another way we might think about it is, are drugs a family or community problem? So restorative justice is the word we often use here, and tribal communities often in wellness courts have used this model with some success, where you bring relatives and community members together to provide support and accountability that is individualized. The hardest thing for this outside of tribal communities is that we don't take seriously the idea of communities and community-driven justice, but even in tribal communities where there's a bit more attention to that, it can be difficult to implement this in light of existing infrastructure and the lack of federal funding for these models. A third way is just drugs as a classification problem. So is this just a behavior that doesn't need to be addressed at all? So thinking about alcohol and marijuana, for example, we decriminalized some of that, and it led just to new industries. There's some regulation involved, but it's not something that we chose to address necessarily through a robust treatment infrastructure. So that is a different model. It's just thinking about declassifying and not addressing in any way. And then another way we might think about it is an economic problem. So could we respond to drugs as a problem by, and Jessica got to this a bit, pouring money into communities or neighborhoods that are affected by it on the theory that the kinds of things that are leading drugs to be a problem can be addressed through an influx of money. So in closing, I'll just say 2 things. One is, my main message is one of caution. It's important to think carefully about what we call alternative models to determine whether they are effective and whether they are reproducing existing problems. I want to acknowledge that addiction and mental health and related violence are really hard problems to consider, and anyone who's dealt with them personally knows that. Punitive incarceration is clearly not the answer, but we shouldn't assume that it's easy to just throw out an alternative idea like a drug court or a restorative justice model, and that's going to take care of it. We have to put a lot more energy into thinking about what those actually look like and what people are getting out of them. And then a more specific note of caution about racial disparities and inequality that Jessica raised. So I've talked about ways that we might re-envision drug sentencing and drug criminalization overall, but as Jessica explained, Professor Eglin, sorry, it is far from clear that finding a new way to address drug sentencing or even drug crime will also shrink racial inequality. So there are a lot of examples of efforts to address a criminal problem that didn't actually reduce the inequality. So for example, efforts to shrink the overall incarcerated juvenile population succeeded for many years, but the native white incarceration disparity remained and even worsened in some places. We've seen this in other contexts as well. So it may be that we have to put anti-racism at the center of any model for thinking about how to reduce racial inequalities, rather than putting just the general problem of drug crime at the center. Thank you.
Thank you very much, Professor Olnick, for those comments. So between you and Professor Eglin, it sounds as though you're suggesting that we really have to consider truly refashioning our approach to sentencing, to our criminal justice system, our approach to what we do and what we've done for a very long time. And so let's see what Professor Hill has to say, and where we sort of all land in thinking about whether our current system can even do the anti-racist work that we're talking about. Professor Hill?
Yeah, thanks so much for the invitation to deliver some brief remarks today. And I'd like to start my own comments today with a quote before turning to some of the figures and statistics that folks might know, but that I think are significant to account for when we are attempting to have a comprehensive understanding of the scale of the issue. But first, the quote. Quote, the Nixon campaign in 1968 and the Nixon White House after that had 2 enemies, the anti-war left and Black people. You understand what I'm saying? We knew we couldn't make it illegal to be either against the war on Blacks, but by getting the public to associate the hippies with marijuana and Blacks with heroin and then criminalizing them both heavily, we could disrupt those communities. We could arrest their leaders, raid their homes, break up their meetings, and vilify them night after night in the evening news. Did we know we were lying about the drugs? Of course we did, end quote. So some of you might be familiar with this quote. It's relatively common. It appears in Michelle Alexander's The New Jim Crow. Pretty much any media account of the drug war also tends to account for this quote. It's from a 1994 interview of John Ehrlichman, who was the former domestic policy advisor to Richard Nixon. And I start with this quote not to imply that the Nixon administration was the originator of drug criminalization. That administration was, of course, not the first to declare a war on drugs, nor would it be the last. But we do continue to witness the effects of this and countless other administrations' hostile positions towards substance use, regardless of their political affiliation. So with regards to some of these figures and statistics, as has been referenced by some of the other panelists, today African Americans are more likely than white Americans to not only be arrested, but once arrested, they are more likely to be convicted, and once convicted, they are more likely to experience lengthy prison sentences. So Black American adults are 5.9 times as likely to be incarcerated than whites, and Hispanics are 3.1 times as likely. And although Black Americans and Latinx people comprise just 29% of the overall US population, they make up 57% of the US prison population. More than 1 in 4 people who were arrested for drug law violations in 2015 was Black, although study after study confirms that drug use rates do not differ substantially by race and ethnicity, and drug users generally purchase drugs from people of the same race or ethnicity. The ACLU found that African Americans were about 4 times more likely to be arrested for marijuana possession than whites in 2010, even though the rates of marijuana usage were comparable across demographic groups. And of the 277,000 people that are currently imprisoned nationwide for a drug offense, over half are African American or Latinx. Prosecutors are more likely to charge people of color with crimes that carry heavier sentences than they are to charge those crimes against whites. Federal prosecutors, for example, are twice as likely to charge African Americans with offenses that carry a mandatory minimum sentence than similarly situated white Americans. And state prosecutors are also more likely to charge Black Americans rather than similar white defendants under habitual offender laws. If we didn't think that this was enough evidence to conclude that this is potentially a structural problem, we also have issues of drug-free school zones, which mandate sentencing enhancements for people who are caught selling drugs in designated school zones. This expansive geographic range, coupled with high urban density, has disproportionately affected residents of urban areas, particularly those in high poverty areas, so largely people of color. Such that legislators in New Jersey had to scale back their state law after a study found that about 96% of people who were subject to these drug-free school zone enhancements were African American or Latinx. Simple marijuana possession was the 4th most common cause of deportation for any offense in 2013, and the most common cause of deportation for drug law violations. So more than 13,000 people were deported in 2012 and 2013 just for marijuana possession. And despite similar usage rates here in Ohio, Black Americans are 4 times more likely to be arrested for marijuana possession than whites. And this was a figure drawn in 2010. And Ohio is among the states with the most marijuana possession arrests in the country. Statewide marijuana possession arrests accounted for about 48% of all drug arrests in 2010. And of course, I think we should juxtapose this with the gradual transition to the legalization of marijuana as criminalization continues apace. So against this backdrop of stark racial disparities and real human suffering, we have anti-racism as a theory and strategy of change. And theorist Robin DiAngelo is often credited with generating the theory, but a host of other scholars and writers can be said to be within this school of thought, including recent MacArthur Genius Award winner Ibram X. Kendi. On its face, the theory seems promising. It is an invitation to not merely be passive in the face of racial animus, but to instead take affirmative steps in opposition to racism. And we have a couple of organizations that have further explained anti-racism, and I wanted to draw from a page on the National Museum of African American History, which, quote, defines being anti-racist resulting from a conscious decision to make frequent, consistent, equitable choices daily, and in the absence of making anti-racist choices, we unconsciously uphold aspects of white supremacy, white dominant culture, and unequal institutions in society, end quote. So according to this formulation of racism, anyone can be racist, not just whites, a stance that Kendi himself confirmed in a CNN interview in 2009, where he stated, quote, you have Black people who believe that they can't be racist because they believe that Black people don't have power, and that's blatantly not true. Every single person on earth has the power to resist racist policies and power, end quote. So these claims, if treated as credible and legitimate, lend themselves to two particular conclusions. The first is that everyone is guilty of racism, such that we've collectively contributed to contemporary racial inequities. And two, that solutions are to be carried out primarily at the individual level, with every person working to cleanse themselves of their racial prejudices. The role of institutions within this framework is to help their individual actors recognize and eliminate their biases. So in my estimation, an anti-racist approach to, say, unjust drug sentencing would be implicit bias trainings for prosecutors and judges. Anti-racism as a theory of change would seek to maybe train police officers to recognize their unconscious biases towards people of color and other marginalized groups, so that they treat those communities and potential suspects with greater dignity. But notably, in my estimation, anti-racism does not necessarily lend itself to the conclusion that the institutions themselves should be dramatically scaled down or possibly eliminated altogether. So anti-racism on its face shares some elements with the colorblind ideology that's been promulgated by state and federal courts following the civil rights movement. Namely, like anti-racism, the colorblind ideology is primarily concerned with the individual. Those adopting this ideology conclude that courts should only intervene where there is intentional, explicit racism, as when an employer makes racially hostile remarks or outright conditions hiring and promotions on a person's race, nationality, or other protected status. But where there is no smoking gun, no particular individual using racial epithets or making explicit reference to race, proponents of the colorblind ideology conclude that racism does not exist, nor should the courts intervene. So more severe penalties for crack cocaine as opposed to powder cocaine, life sentences for first-time drug offenses, as was the case in Harmland, all withstand constitutional scrutiny because no individual legislator or judge made outright references to race. And like anti-racism, the colorblind ideology treats every individual as having the capacity for racism. It is this very presumption that allowed the evisceration of affirmative action, where hiring and admissions programs to address the longstanding history of racism became equivalent to Jim Crow segregation and other discriminatory policies. This type of equivocation could only proceed from a logic that treated individual prejudice found across demographic groups the same as federal and state policies to ensure exclusive advantages for those who had been classified as white. And much like the colorblind ideology holds little to no promise of reversing existing disparities in drug sentencing, I see anti-racism possessing little potential for transformative change unless there is greater emphasis on institutions and power. These, in fact, are the defining elements of racism and racial hierarchy, as has been emphasized by some of the other panelists. Racism, in other words, is not exclusively or overwhelmingly an issue of individual actors with conscious or unconscious biases. Rather, racism is primarily promulgated at a structural level, wherein one, laws and policies preserve privileges and resources for select groups, which 2, affirm and generate ideologies about racial groups, namely that whites are industrious and intelligent, while communities of color, particularly Black Americans, are lazy and incompetent, and that these ideologies in turn justify and legitimize a society wherein Black and Latinx people and Native Americans occupy inferior economic and social positions. I believe that this more precise understanding of racism can generate transformative interventions within the criminal legal system generally and within drug sentencing specifically. If, for example, we recognize that rates of drug use are nearly identical across communities, regardless of race, yet Black and Latinx people are being disproportionately arrested for these offenses, a power-based analysis would have us focus on the differing tactics and strategies deployed by law enforcement in white neighborhoods as opposed to communities of color. So rather than focus on individual bias, we would instead ask, 1, what institutions enable and justify more police in Black and brown neighborhoods? 2, why don't we see police on every corner in white neighborhoods or conducting sting operations on college campuses? And 3, why isn't the natural solution to have a reduced presence of police in communities of color as we currently see in predominantly white spaces? Similarly, if we recognize that mandatory minimums have dramatically expanded prosecutorial discretion and facilitated racially disparate sentencing outcomes, our first inclination should not be to rectify the individual biases of the respective state actors. That is a worthy endeavor, but should not necessarily be controlling. Instead, a power-based analysis invites us to ask, how has our judiciary deployed reasoning to justify and affirm these outcomes? And second, how do communities of color continue to be disempowered by way of voter restriction laws, felony disenfranchisement, and substandard wages from being able to influence the legislators that generate these policies? So ultimately, while anti-racism certainly has admirable goals as regards encouraging introspection about our respective roles within the racial caste system that exists within the country, its emphasis on the individual obstructs a comprehensive assessment of how legal institutions generate ideologies of racial difference, which in turn assure that power and resources are distributed in inequitable ways. Recognizing our individual biases, expanding judicial discretion, or pursuing some specific legal intervention won't necessarily be sufficient to reverse the concerning trends in drug sentencing. Rather, I would encourage scholars and practitioners to instead focus on developing new pathways for impacted communities to actually influence our approaches to public safety, particularly the development of approaches that don't necessarily rely on criminalization to solve persistent economic and social problems. So I will end my remarks there, and I very much look forward to further conversation with the panelists as well as any questions from the audience. Thanks.
Thank you so much. And thank you to all of the panelists for this really rich conversation so far, rich presentations. It's given me definitely a lot to think about. And I have several questions, but I did want to remind the audience that you can use the Q&A feature, and I'll see those and I will post those questions to the panelists. But I wanted to start by saying what I heard in all of your remarks, and even in Professor Hill's critique of sort of the power of anti-racism, or the promise of anti-racism. I heard really, I don't even want to call it echoes, it was pretty much straight out there, the sense that we have to significantly change our approach, whether it is what we criminalize, how we criminalize, who we punish, where we put police, all of that, which seems to be a really huge systemic change. And so I want to ask you all, do you think that it's even possible to get to a point where we have, where we don't see these racial disparities in sentencing and in sentencing outcomes? if we don't make changes beyond the criminal justice system, so all of your remarks are sort of within the realm of the criminal justice system, but can we do all we want to do within the criminal justice system? But if we still have these sort of outside systems of inequality, will we always sort of be where we currently are? Big question, but I wanted to throw it out there to get your initial thoughts while folks put questions in the Q&A feature. And you all should feel free to jump in as you'd like to answer.
So I'll start. I mean, I think the simple answer to that you hear from all of us is no, right? We can't just try and fix sentencing, drug sentencing, without thinking about sort of when and why we use criminal enforcement or criminal regulation and for who. And that those questions are really hard to, to address. And this, this is a point I think that Professor Hill really, elucidates in his comments. Those questions are really hard to address, not just because, this is our preferred way, but because we are sort of conditioned to see the world in particular ways that just make structural marginalization of, Black and Brown communities seem normal, right? And I think that part of the challenge of, thinking about drug sentencing is saying that this is not the place to change. This is a representation of a bigger problem that we have that doesn't just exist within the criminal justice system, but it exists within society. And this shows us, right? These statistics that we are all constantly trotting out show us that there is a deep problem that can't be pinpointed to one intervention or another. And the challenge is really starting to think about, what are all the ways, not silver bullets, but all the ways that we can all begin to rethink, what it is that we're doing through the criminal justice system.
Realize I was muted that time. I was asking if any other panelists wanted to chime in. Go ahead, Professor Hill.
Yeah, I mean, I think I would add that, I think your question emphasizes the interrelatedness of race and class, right? That we can't exclusively talk about, the racial demographics of our prisons and our jails, unless we also account for these institutions as solving issues around economic issues, and namely the prison system as integral, not just to solving economic insecurities, but also generating cohesion around racial identities, right? We often account for the convict leasing system as a new institution that arose in the wake of slavery, but we oftentimes don't talk about the crisis of white identities in the wake of the end of slavery, namely that much of what had been defining white identities was the enslavement of Black people, and that we see the assumption of the criminal legal system as yet another mechanism to distinguish particular racial groups. So I think that your question ultimately emphasizes that if we don't really center and account for the role of myriad structures, the role of various institutions, not just in generating racial disparities, but that this is a solution for, again, substandard wages that affect multiple racial groups, right, that are not exclusively affecting Black and Latinx people. And so I think even when I emphasize in my remarks that oftentimes what does it mean to have a felony conviction or a criminal record to be in prison, you're unable to exercise rights that are integral to being a citizen. And so the idea, for example, that politicians naturally represent the interests of impacted or marginalized communities, I think that that's a questionable presumption that we really don't fully appreciate or account for if we exclusively understand the ramifications of the criminal legal system as operating along racial lines. So I absolutely think that if we want to have robust conversations about reversing these really concerning trends, how did we become the leading nation in terms of incarceration? how has this been a long-standing practice here? I think that we have to not merely grapple again with how are people's individual biases causing these particular outcomes, but how is this a recurring solution to economic differences, but namely labor exploitation? How are wages kept exceptionally low for working class people? The prison system has a tremendous role in that, and I think there are plenty of scholars that have addressed this, from Ruth Wilson Gilmore by way of Golden Gulag to a host of others.
Thank you.
And I'll just add a bit here. So, so just breaking your question down, I agree with everything that Professor Hill and Professor Eaglin have said. But you think you asked two things. One is there a way to address a lot of these problems via sentencing alone? And then do we have to address things outside the criminal system, right? So as to the first part of it, my answer is also no. So there's no way to address any of the problems that we're talking about just by fixing sentencing. And I guess I want to say more explicitly what I think we're all saying, which is if we come in and say we'd like to adjust what we're doing in terms of drug sentencing in order to fix the problem of racial inequality, then we're assuming that it's an accident, right? That we sort of had, that we made a mistake and that mistake has resulted in unequal outcomes. And if we could just adjust our system. And I think to some degree or another, we have all suggested, and it's worth saying explicitly, that it's not an accident, right? So alternatively, we could think of the current approach to drug criminalization and sentencing, specifically drug and alcohol, as an intentional regime that was put in place in order to achieve racial control, right? So there's lots of scholars who have argued that. There's a lot of literature in the context of thinking about drug criminalization for Black communities. And I think it's also true if you look at the way that the criminal system has been deployed against Native communities, particularly with regard to the idea that alcohol abuse is rampant and it has to be addressed through criminalization. And so no, if we just kind of look at the sentencing, then we're kind of missing the whole point. And I think we all said that in different ways in our remarks. And then you also said, do we have to address, inequalities outside the system? So yes, but I wanted to push on that a little bit more. So one thing is, it's been helpful for me to think about what I guess is a circular relationship. So one thing is we have things outside the criminal system that input people into the system, and they maybe are, we could think of them as not affected by the criminal system, but they input people in, and then the criminal system has its own built-in disparities at each level that compound the outside inequalities. But the other way that I've started to think about it as important is the other side of that relationship, which is the experience of being in the criminal system at every level, the experience of criminalization and punishment, also then compounds the outside problems. So it's not just an input into the criminal system question, but it's also what we're doing with criminalization. So I think by thinking about sentencing, for example, we could mitigate some of the ways in which the criminal system has worsened the outside inequalities. It wouldn't address the whole problem. But for drugs particularly, it is worth just thinking about what's the problem we're trying to address. So Professor Hill mentioned that, for example, rates of drug and alcohol across communities are the same, and yet we see different levels of criminalization. So if that's true, what's the problem, right? So yeah, we need to address racial inequality outside of it, but sometimes I have questions about whether we need to address drugs as a specific problem, which is to say that if they're only being addressed through the criminal system as a mechanism of racial control, maybe they don't need to be addressed as a problem. If the rates really are similar, then we ought to be really careful about how we construct, is the problem, as someone suggested, neglected children? Is it violence that comes from drugs? Is it just the problem of possession? Is it sales and dealing? So what is it that we're trying to stop? And that would tell us whether we needed to intervene and how.
Thank you. And we have a few questions in the chat. I had a follow-up for you all, but I want to let the audience get in. So I'll ask a different one. So we have a question that's about, it says, it seems easier to achieve legislative changes to lower penalties for personal possession of controlled substances, since a number of states have already begun that trend, than it would be to make more substantive changes like the ones that you all have been talking about, legalization or decriminalization. So are there ways to push for drug decriminalization in ways that don't result in continued inequities? And so, this goes with another question that's also in the chat, which is about, what do we do now while we're waiting on these bigger systems of inequality to change? what would you say is a good tactic for now? Or small bites at things, just not what we should be focusing on at all? Is that just, the wrong approach?
I mean, I'll just start by saying, I do think, and this is always a hard conversation to have, the more you talk about small bites, the risk is then we will not see the larger things that need to happen. And I think that's where we're all pushing. But we really do have to do both. And you can hear from what I've been saying that I'm fairly critical of some of the kind of diversionary models, but at the same time, I've been swayed by listening to a lot of people who are involved in thinking about community-based and diversion models that are somewhat promising in arguing that it's fine to append them to the system that we have, right? So that we might be able to find the pockets, right? So there's certainly, it's not going to be bad to change sentencing overall. It may not address the problem of inequalities, but I don't think it's going to, well, sometimes it does worsen them, but hopefully if we're careful, it won't. But also exploring some of these unproven ways in which we can experiment with other models that might not go as far as we want. So pushing people into some kind of treatment program is not that as exciting as talking about getting rid of the whole system. But it might be a place in which we can find things that work better, and we can start to put more money and more support there. What I think is really key is that as we talk about this, we spend as much energy in thinking about how those approaches actually work. What I have noticed is that we don't. We sort of say, here's an alternative, it sounds good, let's do it instead. And we don't have any idea what that alternative looks like. I'm not sure that we don't know what a drug court is. We don't know what it entails. We don't know what restorative justice looks like, but we just keep throwing those around. So I would say more money, more energy into developing what non-punitive models might look like. And that can be done by kind of sneaking in and making little changes.
Thank you. Professor Hill or Professor Eaglin, anything to add there?
Yeah, so first I want to say I love that question. I think that the more we can grant ourselves the space and the opportunity to think through alternatives collectively, the better, right? And I think that oftentimes the issue is posed to those who are critiquing the criminal legal system as, well, what's the solution you're proposing? What's our immediate intervention? And part of the response, at least on my part, is, well, I want us to collectively think through this. And I don't think that there are many opportunities made by way of structural actors for us to collectively operate in community with one another. What does it mean, again, for us just to know our neighbors and to be having these conversations with one another? So one, I just want to say that the more that we can facilitate in this context individually, conversations with other individuals, I think that is an incredible step towards reversing many of these trends. And even though, I had this critique of anti-racism in some sense with its focus on the individual actor, I do appreciate it as, again, an invitation to think through some of these issues, race as a social construction, it encouraging us to understand where we've been so that we better understand why do we continue to confront the same issues. I think oftentimes there's a misunderstanding from the public as well as practitioners about the fact that these have been recurring issues, that we constantly are dealing with the same strategies and they are successful every time. So I do want to say that just engaging in individual or collective study, having a reading group, these are important and significant, not just in terms of building our own knowledge, but also developing community. Some of the critique that is leveled at the mass incarceration, the war on drugs, is that it has really alienated us from one another, that we are oftentimes in fear of our neighbors and our community members. And part of, again, addressing this issue is that we have to return to a sense of community, both to generate new solutions, but also address, again, these what feel like intractable problems. So I would just ultimately say that my background is as a practitioner, but supporting movements, supporting individuals that are engaged in actions and public demonstrations. And part of the motive and drive for my participation was coming to appreciate how occasionally the legal system can obstruct and interfere with what communities and the public actually want, right? That many of the rights we have today were not necessarily the product of some legislative intervention, but really the product of years of real action and demonstration on the part of marginalized communities, whether women, people of color, or otherwise. So one other recommendation I would make is, for those of you who are interested in doing lobbying work, speaking to your state legislators, I think that that is fantastic. I think that, understanding the distinction between decriminalization and legalization is especially significant. We want to certainly see decriminalization, right? Before we move into the realm of legalizing substances and allowing people to draw tremendous profits, we really need to be focusing on ensuring that people are not currently being punished for what is otherwise a basis for drawing profit. So I think that when we go and we engage in advocacy, it's important to, one, be clear about what types of demands we should be making so that we are not interfering with what impacted communities actually want. And then I think, again, pursuing and investing your time and your resources in non-legal interventions. I see we're at the end of time, but ultimately contributing to organizations that are engaged in public action and public demonstration. I think that that is incredible to really support people who are on the ground.
Wonderful. Thank you. That is a great note to end on. I want to thank all of you for joining, and thank you so much to the panelists for really fulfilling my dream of having a conversation that goes beyond just racial disparity numbers. So thank you so much. And I look forward to continuing our conversations in other symposia and conferences. Thank you all.